6.87(4)B, and that section requires that the envelopes containing the ballot shall be mailed to the elector and or delivered in person to the municipal clerk who issued the ballots. So here we have people putting ballots in drop boxes. We have parties in the park where people are being witnessed there by someone who is available, and those ballots are being collected, but they're not being delivered in person to the clerk, and they're not being mailed. And that frankly troubles me. I don't see how that fits within the statute. Can you talk about that a little bit, please?
Of course. The first thing, again, as a factual point, I believe needs to be emphasized. We are not talking about drop boxes in this case. The plaintiff has not challenged the use of drop boxes, of which there were, of course, many aside from what has colloquially been called the democracy in the park. There have been challenges to drop boxes in other cases, but as I understand the claim here, it is simply a challenge to the democracy in the park event, which I think has some very important factual attributes that answer Your Honor's question. I think, again, the relevant statute here is 6.87 sub 4 sub B sub 1, which, as Your Honor correctly note, requires the absentee ballot envelope to be either mailed by the elector or delivered in person to the municipal clerk.
Right.
And I think if you look at the facts of what happened at Democracy in the Park, the in-person prong of that statute was satisfied, because what happens at Democracy in the Park, again, is a factual matter. I think it's very important to emphasize there were no ballots given out to voters at this event. It was simply a collection event. All that happened is people, the agents of the Madison city clerk were present at these events and collected ballots. And I think that satisfies.
Oh, I don't think so. Otherwise, you'd have to say this is, which Madison could have done, an alternate absentee ballot site under 6.855. And you have declined to assert that. And the city itself said, no, that's not what it was. So they're not delivering it to the clerk. They're delivering it to agents of the clerk that are set out in the park, but they're not delivering it to the clerk in the context of 6.874B1.
So I have two responses, Your Honor.
Okay.
First is, I think clearly delivery to agents of the clerk has to be permitted, because that's what happens even at the office of the clerk. There's one city clerk for Madison, Mary Beth Witzel-Bell. And I promise you that not every single person who returned a ballot in Madison hand-delivered that ballot to Mary Beth.
But counsel, reading the statute in context, don't you agree that what is set out there contemplates, it says mailing it to the clerk who gave out the ballot or delivering it to the clerk who issued the ballot? And that contemplates the clerk's office from where these are sent out. Certainly not apparent to me in the statute that you could set up a clerk here, there, and everywhere and say you're having the clerk's office, unless they decide to use the separate alternate provisions in the statute, which could have been done, but we're not here.
And